And that's why it's very important for our baba or disclose my property.
Writing
Because
witness.
someone dies and then the property is due out.
Instances where Baba disclose property yake alafu anamalizwa because the wife knows what the Baba has.
Hello and welcome again to another episode of the Sisters-in-Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we'll be discussing matters law.
From talking about contracts to discussing employment laws to discussing laws on inheritance, anything that the law can literally cover, we got you covered.
Remember to like, share, subscribe, and comment.
So in this episode, we are discussing about the laws on inheritance. Someone once said that life is a risk. And how do you know that life is a risk? Because you won't make it out alive. Yeah. So it's important for us to normalize the eventuality of death. And how do you plan around that, you know? So how do you leave the people that you leave behind? Yeah. Like, you know, how do you take care of, how do you make sure your property is in safe hands? And how do you make sure that the people that should benefit from your property or your estate are not left behind fighting or disinherited completely? So I know that most Africans don't like to think about death or plan around their death. Maybe because they think that if they do that, they will die sooner than they would
have.
Yeah. So, but it's very important. So you get that some people usually die and leave a will behind and others do not. And there are different processes in court and different procedures for either instance. Yeah.
Okay, so what is really a will? So a will is actually a document that has been written by an advocate for a testator. So a testator is the owner of the property. So maybe it's a father, a mother, or maybe a sister, whoever, who is the owner of the property. So who lists down the properties that they have and their beneficiaries. So you have to list down all the properties that you have and all the expected beneficiaries, those you expect to benefit from your property, from your estate now in this case. So you would write if it's your children, your aunties, and whoever.
A charity organization.
Yeah. Even if you want to give to like the poor, the widows, and whatnot. So those would be your beneficiaries. And then now, it's also important to note that they should be accurate. If it's maybe shares, if let's talk about shares. If this is the exact number of your shares that you have, maybe in Safaricom, and this is the value of the shares that you have, so it should be specific to say what the property is and who is going to take what. But you will also realize later that in as much as it is in the discussion of the testator to divide their property the way they want, in the instance where a beneficiary feels that they have not been given enough property, they can go to court and have themselves added some more property. Yeah. So that's like what really a physical will is about. But
so
then
you're
also,
saying that it's like this person who's dying, not this person who's dying, this person who has left a will behind, or as you're writing your will, you're supposed to be clear on who are the beneficiaries that you want to benefit out of your property.
Yeah.
It could be anyone. That's the freedom of writing a will.
Yeah.
Because you have the freedom to choose who is going to benefit out of it.
Yeah.
Now, if you don't leave a will behind, the courts, like no one else can come outside of, let's say, your family or maybe people that you are supporting
on you,
I think like 2 years before your death,
yes,
to claim property. So at least if you're writing a will, you're able to give it to
the people that you want.
Yes,
your friend,
to support a cause
yes,
somewhere. Maybe if you like, tree planting or whatever, and there's a tree planting organization, you can channel
Give
some
them.
of your property
Yes.
there.
Yeah.
Oh, okay, yeah.
So you could also have there are instances where your will can either be written or oral. So in written is one which is on paper, and it's where you now list all your property and the beneficiaries. And then now there's the oral will. Yeah.
Even before we go to the oral will, I think there's something you were saying about for someone to be able to know their property and their beneficiaries, or basically for them to be able to write a will, there are actually some prerequisites that they're
Yes.
supposed to have.
Yeah.
Like you said, age.
We said age, we said capacity, and we said also knowledge and approval.
Okay.
So for age, you must be 18 years and above. If you're below just the normal knowledge, age of consent, you must be 18 years and above for you to be able to write a will. So if you write a will before you get to 18, then it's actually invalid ab initio.
Yes.
Actually just
On the face of it,
yeah,
it's
on the face of
invalid.
it, yeah.
Yeah.
And then now you go to capacity, which goes down to soundness of mind. So how sound were you at the time
Of writing
of writing the
will.
will? So if you were sick, maybe you had dementia, or maybe you had an illness that actually messes around with your mind, we could challenge the soundness of your mind in terms of capacity. However, it's also important to note that there are people, when there are those delusional people, they can write wills, but they can only write their wills during their lucid moments. Yeah. Yes.
Yeah.
And then on knowledge and approval, you should be able to know your property precisely. I own a house.
If it's a house in
in Ngong.
on this land,
Yes.
specific land, you have to specify the
So,
land number,
you should
land
be able
reference
to
number.
know your property.
Yeah.
You should be able to acknowledge who are your beneficiaries.
Yeah.
So maybe it's your child, or maybe your siblings, or whoever. You should be able to identify them. So that's what, like, if you're unable to identify your property and or your beneficiaries, then the will can be challenged
On the
on that
grounds
basis.
of
Yeah,
lack of
knowledge and
soundness of
approval.
mind.
Yes.
Yeah.
There's also the other side of wills. It must not be written. It could be oral.
Yeah, by the way, it could be oral in the event that maybe this person is illiterate, or maybe they just died before they knew they were going to die. Yeah, people usually know when they're going to die,
Yeah,
apparently. Yeah, so they might say that when I die, this and this and this will go to so and so, right? So in this instance, there has to be two independent witnesses. So I'm saying person A, in the presence of two independent witnesses, might say that in the event that I die, I would want my property or property X to go to person Y. So the court would usually consider an oral will to be valid, or a valid way of transferring property, if there are two independent witnesses and if this person dies within 3 months. So if this person dies, let's say 4 months after, then the will is invalid. There's this client of ours who she was married. She is married to a man, right? A Maasai man. And this Maasai man has 3 other wives. So the dad to this Maasai man knew he was going to die. And he knew that because this lady does not have a child, these people might kick them out. And the dad of this, now the person who died, the deceased, knew the kind of son that he had. Yeah, like he knew that his son would disinherit the woman, or would kick them out, or things like that. So what this guy did before he died, he called the people around, like the elders, the cousins. You know, in Maasai culture, family is very important and things like that. So he called all these people and said, in the event that I die, this lady is not to be kicked out of this home in whichever circumstance. And akawachukua, oh sorry, like he took them round to like the land that he has, because he has a vast piece of land, you know, the Maasais and the amount of land that they own. And they put beacons. Like beacons could be anything. Beacons is something to divide the land. Like in this case, it was cement and sticks around the land. So he said that these 5 acres belong to this lady X. Remember, we said with wills, there's testamentary freedom, like there's the freedom to give anyone your property.
Yes.
So even if they're not your biological children, you can give them that property. So what this guy did, he said, when I die, this lady is not to be kicked out of this house, whether she has a child or not. And these 5 acres where she had built her matrimonial home are going to go to her. Like no one is supposed to disinherit this lady. So now this man dies within within 2 weeks of saying that. I think he knew that he was going to die. So after 2 weeks of after dying, now these people go to court, and they were saying that there's no will, like there's no will. This man
Okay.
didn't leave a will behind. So they're saying that all this property will go to his sons. One of the sons is this guy who's the husband of this lady. So now what we did in court, we went and challenged and said that this man, although he was not the biological father of this lady, left behind land to her
Yeah.
in an oral will, whether or not she is his biological daughter. Yeah. So like in such instances, for as long as there was an oral will and you can prove, the good thing is the chief was around, the cousins, some of the stepbrothers were around, so she had enough witnesses to be able to attest to the fact that this guy left behind an oral will before dying, and so at least she was able to get the court to rule in her favor. Yeah.
Okay.
So for as long as this guy has not died, let's say 3.5 months after, if it's within 3 months of giving that oral will, then it's valid. Now the thing is, you're supposed to get witnesses, if possible. Let them write minutes. Get a local administrator if it's possible, so that at least you have it on. Like the minutes of that meeting is put on record.
Okay.
Yeah.
Okay, that actually makes sense now. On the issue of the oral wills. So like also, for it's different for people who work in the sea or even the military guys who can have one witness, and theirs does not
Limit that time.
that time limit is not there, because for them it's a different circumstance.
Yeah.
But as long as it's within duty, like the period, if it takes a longer time for them to die, they were in duty at that time, like maybe on sea, or maybe they had gone for a military assignment or something like that. Yes.
So for example, someone says, oh, we're going for peacekeeping in, I almost said that country.
Yeah.
Peacekeeping in such and such a country, and in the event that I die, my property should go to so and so.
Yeah.
They only need one witness, and they don't have to die within 3 months. If they
Yes.
die, so long as they're
still in
the
line of duty.
line of duty, then the property can be distributed based on their wishes.
Yes.
Validity.
When we go to the validity, when we want to see if a will is valid, there are like three compulsory factors to consider. Was it executed? Were there witnesses? And also, I don't know,
executed, you said, you mean like signed? So a will could be invalidated by a lot of factors, a good number of factors. Yeah. For example, now like the one we already mentioned before, the one on undue influence, whereby let's say you had a caregiver,
yeah,
and they forced you, they manipulated you based on, let's say, your meds, or taking you out to see the sun.
watch the sun.
Yeah. So other
so
factors could be,
we could have coercion also, like just being forced. Like they could coercion, and there's now insistent begging.
Yeah, no, coercion. So it's like at gunpoint.
But yes, but insistent begging is just, could you please? Can you please?
Please
Could you?
just do it.
Yeah, like that story of the widow and the judge in the Bible. You beg until you're put in, you're included in the will. So could also have fraud, like maybe someone just found their way into being in the will.
Yeah.
And then we could also find a mistake. Like for example, if a testator was looking at correcting his will. So maybe you intended to correct that. Maybe, so when you sell a property and it was in the will,
you need to remove it.
You need to remove it.
Yeah.
So it's not there. So now, for example, a testator tells his advocate that I sold this car, so I need it to be removed from the will. But now the advocate maybe misunderstands and now messes up all the other beneficiaries.
Yeah.
Like maybe by moving, shifting the properties. Now we could question the will on the basis of mistake. Yeah. And then there's also now inopportunity, which we had said is just the same as insistent begging.
Yeah.
Yes.
So if when you go to court, you're supposed to deposit the original will in court.
Yes.
And if someone comes and says that this will is not, like maybe let's say a beneficiary was left out of the will, and they come to court and say that this will is not valid, because they would want to actually attack it based on its validity first. so that maybe if the court decides that the will is invalid, then we can go to now intestacy, where maybe you assume that this person died without a valid will.
Yeah.
So like if someone is coming to court, then they could challenge the will based on the grounds that you've mentioned. Say that this person was coerced, or maybe his mind was not sound.
Yeah.
The ones that you mentioned before, capacity and soundness of mind, and this person knowledge of beneficiaries, like, so you say that he did actually list all his beneficiaries
Yeah.
because he didn't have soundness of mind. I was left out. Yeah.
Yeah.
Or maybe this person was coerced. Person X is not supposed to be on the will. They
Yes.
coerced them, or the undue influence, or the church bit that you mentioned. Did you mention the church bit?
Yes. Of
Like
the
for
pastor.
example, yeah, like a pastor maybe
Yes.
can
Having so much influence on the testator.
on the testator.
Yeah.
And
So I just remembered right now that there's something we forgot, that there must be an executor of a will.
yeah,
Yeah, and it must be mentioned in the will that this executor is going to execute. Like executor, execution,
yeah.
potato.
So an
Just
executor is someone who's now the person who manages the property. He's the one who
yes.
will give to other people, to the people, transfer and things like that.
Yeah.
To the beneficiaries in the will. But there are actually some wills where the person does not mention an executor, and
Oh,
then it will
wow.
have to go to court, so that you will do like grant of letters of administration with will annexed. Maybe like that's just legal jargon, but like there are instances where maybe the deceased would leave out an executor. So now that will would still be valid, but now when you're going to court, now you'll have to get an administrator. Like the court will have to appoint an administrator, or maybe like two people. Let's say the son and the wife can come, or just the
Together.
son alone or the wife alone can come and say, "Oh, there's a will, but there's no executor. I would want to be
The
the
executor.
executor in this will."
Okay. That's
Yeah.
fine. I really can't wait for us to have the conversation on intestacy.
Right?
Yeah.
Yeah, it's very broad, and it's actually the most common, because like we said, most people don't leave wills behind.
Yes. So now we've come to the end of this video. Thank you so much for watching. Remember to like, subscribe, and share. Also put the comments below on any questions.
If you have any questions, and if you would like us to cover anything or tackle anything that you're curious about, or maybe a problem that you would like
Shedding of light.
us to shed light on.
Yes.
Remember, like, it's not a viewers discretion, it's not legal advice.
Legal advice, yeah.
But yeah, just you could ask and we could give you our opinions on it. Thank you, and see you next time.
Till next time.
Bye.